Our next presentation is on navigating discrimination and harassment claims brought by a current employee in the Me Too era, so something that's very timely. This panel is sponsored by Morrison Mahoney. Gareth Notice is a partner at Morrison Mahoney. His practice focuses on transportation, employment and labor, education law, municipal premises and products liability, tort and liability defenses, civil rights, defamation, and discrimination. He regularly defends individuals, corporations, and municipalities in employment-related matters, including claims of discrimination, harassment, wage and hour, whistleblower claims, and wrongful discharge claims. And I'm going to turn the program over to Gareth.
Thank you so much. So a large part of my practice involves harassment and discrimination claims. I'm a certified investigator by the MCAD. We're going to talk a lot about investigations today and sort of remedial measures that we're going to take when we have a crisis involving a senior executive. So in the day-to-day, what I do is I might get a call, a very urgent call, that there's been a report of harassment or discrimination, and they need either counseling, which is part of my practice, or they need an investigator to come in and perform an independent investigation, interview employees, and then ultimately reach a conclusion. I'm also a trained trainer, so I go into employers and I provide sexual harassment and discrimination training, which is something that I think most good employers will do on a regular basis. I think we've got a great panel today. I want to introduce Sandy. Sandy is the co-founder and principal of the Castle Group, which is a women-founded and owned 23-year-old public relations group. Sandy, why don't you tell us a little bit about what you do on a day-to-day basis?
Sure. Good afternoon, everybody. My firm, the Castle Group, is predominantly a public relations firm, although about 35% of our business is corporate events management as well. And on the PR side of our business, on a day-to-day basis, there is no average day in the crisis world. A large amount of the crises that we work on have to do with the issues we're going to be talking about today. We get incoming calls from folks we may have never heard of or spoken to before that are in the middle of something or something is bubbling up. We have a lot of proactive retainer clients as well, but which we could speak to another time. But on the crisis side, what we do on a day-to-day basis is at the end of the day help people mitigate against risk and think about how to use all the channels, and I don't want to get ahead of the presentation, but all the channels that you heard in their previous presentation, and to use planning to protect their brands, their reputations from risk relative to crisis.
Hi, everyone. My name is Cara Del Tufo. I'm Associate General Counsel at Dana-Farber Cancer Institute. The title of this program is sort of interesting to me because while I think these are things everyone thinks of as a crisis, for me this is sort of business as usual. So I pretty much handle all of our day-to-day employee relations matters that sort of escalate to a legal crisis, if you will. So a good example of sort of a day in the life is sort of the very final stage of the crisis, which is the litigation, sort of overseeing employment discrimination litigation from former employees, all the way to sort of what I always hope to be doing more of is the beginning end, which is when I have human resources or perhaps another senior leadership come to me and ask to sort of work through a problem that they think could become a crisis and sort of to help them think about what are all the different legal pitfalls as they make decisions. And then sort of the middle stage, which I'm also dealing with now, which is the investigation stage, and we'll talk more about that too, but that's when that problem starts to develop and gets to be even bigger of an issue, and now we have to think about how to more formally respond to it in a way that's organized and sort of best sets us up in the event that this does turn into litigation.
So I think we've got a good perspective on things. We have the in-house perspective, legal perspective. Sandy's going to give the PR perspective, and I kind of can provide the investigator/outside counsel perspective. So the context of our presentation really is you have a stakeholder, a principal, perhaps a board member, someone of importance within your organization or company who's been accused of some type of harassment or discrimination. And in the Me Too movement, how that's really impacting how you're going to handle a crisis. And we thought that it would be helpful if we talk about it in the context of a recently filed MCAD or EEOC claim. So you've got an executive, someone of value to the company who's being accused of harassment or discrimination. There's either an internal complaint that comes in to Kara's office, or you're thrust into the fire and you're handed or served with an MCAD complaint. And how we're going to handle this, there's a high potential for media coverage. So this is sort of the global hypothetical that we're working with here. The agenda, we're going to touch on the Me Too movement in general, give a little background on it, immediate remedial steps that we might take, and a public relations strategy for dealing with it. The origins of the Me Too movement. As I was preparing for the presentation, I think what struck me is how sort of new this issue is. Really, in 2017, when Harvey Weinstein was accused of harassment, that was really the pivotal moment in the movement. And since that time, I mean, this was only 2 years ago, we're in October 2019. Since that time, we've seen the fall of, some really high-powered people, Matt Lauer, Charlie Rose, Tom Brokaw. It really impacted the Judge Kavanaugh hearing. Just yesterday, there were some revelations about Congresswoman Hill out in California. And she was, if everyone doesn't know the story, she was elected to Congress. She's sort of an up-and-coming congresswoman from California. She's openly bisexual, and she was engaged in a relationship with a staff member, and some videos were posted on the internet. So this is happening on an almost daily basis, which I think is really striking. Some of the impacts of the Me Too movement, of course, I think there's positives and there's negatives to it. It's going to root out harassment, hopefully improve your workplace culture. It's forcing companies and organizations to revisit their policies, and ultimately, hopefully, we're having a more productive and safer workplace. Kara, at your company, have you, since the Me Too movement really has evolved, have you revisited your harassment and discrimination policies, investigative practices? How has it impacted your industry as a whole?
Well, I think, it's interesting because my industry, and I think of it as sort of an academic medical center, but also a place that's affiliated with Harvard Medical School. And so it is a very hierarchical type of organization. You have employees that we refer to as faculty, or tenured faculty at Harvard Medical School, as well as our doctors. And they're perceived by a lot of employees in the organization to have a lot of power. And so I think what it's helped to do is really get at some of those dynamics in the workplace. I think that employees, particularly the ones who do not perceive themselves as having sort of the power of the title or the credentials, feel a little bit more empowered to speak out about conduct in the workplace that they don't agree with. And what I've seen mostly is sort of an uptick in complaints about behavior that may not rise to the level of legal liability, but it is, bullying in the workplace. It may not be based on a protected characteristic or a hostile work environment. So it's really getting at a lot of those bad workplace practices that have been there for a long time. At least that's sort of how I've seen it. The other side of it, too, is that there is certainly concern at a more senior and board level about these sorts of claims. And so for employment lawyers like myself, it's a nice tool for us in some respects to say, we've always been telling you these issues are important, and these issues are important. But this external pressure has now sort of escalated the importance of these issues to bring it more to the forefront of people's minds when they're trying to juggle between a number of different competing priorities.
So, of course, there's negative impacts as well. I think it's impacting retention and hiring. It's increasing claims, as Kara mentioned, but it's also damaging the brand and reputation of companies. Sandy, can you talk about, just in the context of the past 2 years, has there been an increased sort of awareness amongst your clients in how it's going to impact their brand and their reputation in their industry?
Sure, and something interesting that we were talking about in our preparation call too is it's not just the organizations that have Me Too allegations that they're dealing with, But organizations, for whatever reason, that might be conducting an internal investigation around an employee are immediately thought to have a Me Too situation going on. That's the conclusion that people jump to. So whether or not you're actually wrestling with a Me Too type of issue, you're wrestling with it anyway if you have somebody being alleged to have done something, because that's what people assume. And I think what we're seeing today is in the crisis planning that we're doing, every single crisis plan has to be prepared for how to deal with this situation. The plans we put together have various scenarios so that any client of ours knows what to do immediately if something hits the fan. And in the past, there were no Me Too pages in the crisis plans. There might have been workplace discrimination, litigation, but they're very, very specific now because by nature of the movement and the fact that it is a movement, there's context for all this, it immediately becomes news.
And our last bullet point is about resentment internally if a crisis isn't handled correctly. One of the slides we're going to show later is of Matt Lauer and NBC's decision to perform an internal investigation of him, in other words, performed by its general counsel, rather than sending it out to an investigator to have an objective investigation. And I think the general consensus is that that was a poor decision. And amongst, not only did that impact their brand and reputation, but I think internally there's been a number of anonymous employees who have voiced complaints about the way that investigation was handled. So, Kara, is that a concern for you? In other words, when you have somebody in your industry who's accused, perhaps in a high-profile situation, is that a consideration? How this is going to impact your workforce? And secondly, what sort of measures might you take to kind of cut that off?
Yeah, I mean, certainly, yeah, we're thinking about sort of, yeah, what's the impact on the workforce who know about the conduct and what sort of accountability is there if we do have a finding that it has been, conduct that, is inappropriate. So that's one of the things that, we try to think about. The other part of it too, and this really depends on how a complaint comes in, because certainly at certain levels of the organization, we're going to need to have an external investigator do the investigation, regardless of what our in-house capabilities are. We, not only do you have the perception issue internally with the employees, but also thinking down the road that if this does turn into litigation, you want your investigation to be defensible, and you don't want anyone to be able to, criticize any sort of perception of, partiality on behalf of the investigator. So that's an important part of the decision-making.
Do you, in your industry, do you think it's common to perhaps communicate with the employees when you get sort of a high-profile complaint for a number of reasons? One, to quell perhaps concerns and resentment amongst the workforce, but looking down the line, like you said, towards litigation, you don't want public comment out there, particularly with other members of leadership about the situation, and you want to have sort of a unified strategy that you're putting out there.
Right.
So is there internal communications that you might engage in?
Sure, yeah. So I mean, again, depending on the complaint that we see, because we really do see so many complaints on a regular basis, so it has to be one, I think, that sort of stands out either in terms of the people that are involved, their level of profile, or the seriousness of the allegations. And when we do have those, it's very important for us to partner with our SVP of communications and make sure that communications is aware and prepared. And then we also want to alert all of the people that need to know. So again, depending on how high profile that is, we need to make sure that executive leadership might know about it. In a rare instance, you might want to consider whether, the board leadership might need to know about this as well. But we also have to be really mindful, because on the one hand, you have the person who is coming forward, and if they're still a current employee, they may have concerns about confidentiality. And then you also have the person that's being named. And this is at a really early stage in learning about a complaint. So we can't act in a way that then sort of creates an impression of guilt before we have anything to be deciding about. So we have to be really mindful, particularly in a high-profile organization where professional reputations really have a lot of weight. we're trying to balance everybody's interests at the same time. So yeah, we do try to make sure that we're speaking to all the people that have a need to know, people who complain, people who might be sort of immediate witnesses, and assure them that we are aware of the complaint, we have a plan, we're going to be looking into it, and they will be hearing back from us. And then we have to sort of balance asking them to keep this confidential so we don't disrupt the investigation with rights that they might have under the National Labor Relations Act or other sorts of employment laws that are out there to be able to speak about their workplace terms and conditions.
And one of the things we were talking about in preparation was fairness to both sides. So you just talked about the balancing of the equities. You have to be mindful, I mean, I think the Me Too movement has almost created this air of believability for the complaint. In our skeptical world of maybe employment management side lawyers, we're always looking at where's the frivolous aspect of this. But I think the Me Too movement has shifted belief and credibility to the complainant side. But I think you mentioned earlier that you're always trying to balance the fairness to the accused, particularly in your industry where you have academics.
Right.
And you have people whose professional reputations are on the line, and a simple Google search for the next 10 years is going to pop up about the sexual harassment claim.
Right, exactly. And especially, I mean, when we see things that are really based on, and I think this is common with the Me Too movement, where you have the imbalance of power, right? And you have this person who doesn't have a lot of power within an organization that's bringing the complaint. You know, it's easy, particularly when you have a powerful person who has this impressive reputation that people know and like and have worked with for however many years, to immediately want to take their side. I mean, I think that happened a lot. We saw that in the Me Too movement. And what Me Too has sort of helped me to communicate a little bit more to my clients is, let's take a minute and pause and really think about the person who's complaining and what their perception is. I mean, I think we've always considered that perception, but I think we just stick a minute longer there, because what Me Too has shown is that people are telling the truth when they're coming forward with these claims. So it really causes us to say, well, don't immediately jump to the conclusion that this person isn't telling the truth, because we've seen this happen in our culture, that they've been shown to be truthful.
So the next slide talks about why Me Too is making the news. Sandy, from your perspective, externally, what are some of the key elements of why the movement is causing such newsworthy events?
Well, I mean, again, the word movement is a bit, you know, it's very telling. This isn't something that's episodic. It has become, as you've talked about, things changing over time and becoming more frequent. It has become a movement. So when something is alleged to have occurred, it's part of a big contextual story. And it's another one. It's another drop in the bucket. It ties in. It's a day two story to something that's happened the day before. So it just continues to be part of what's out there in the ethos. And we're seeing it online, we're seeing it in traditional media, we're seeing it in conversations within the walls of our organizations. So there's that external context. But also, to your point, Kara, it's very emotional. You know, this involves people's feelings, people's perceptions, people's public standing, regardless of whether it's the accused or the accuser. It's very, very emotional. So people have very strong opinions about it, very knee-jerk opinions about it. And then there are external folks that have a stake in what's happening in this movement that can be fanning the flames to try to get the story more visible, because it might support a cause that they have, regardless of which side of the equation they're on. So there's external forces. You can't just think about what's happening in your own organization. You always have to be thinking about the outside context, and if this is going to be part of something that's already happening, and therefore rise to a higher level of visibility.
So I think within the world of MCAD complaints, and that's sort of before somebody files a lawsuit initiating a discrimination claim, they have to first file at the MCAD or the federal equivalent, the EEOC. And prior to 2017, really there was a dip in claims. They were going down, and for a lot of, I think, reasons. One, employers were taking a more proactive, responsible approach. They were engaging in more training, and you just had a more, I think, educated populace and generationally had grown up with awareness of harassment and discrimination. But interestingly, you know, once the Harvey Weinstein news hit and the Me Too movement took off, claims have spiked. And not only have they spiked in the world of sexual harassment, but they've also spiked, I think, across the board. So in my practice, I've seen a sharp increase in complaints about disability, race discrimination, almost a political discrimination. I think the political climate right now on both the national and local level has contributed to the increase in complaints. And so I think it's just created a lot more awareness of the ability to complain, to lodge a complaint internally or perhaps file a lawsuit. So we've seen a huge increase in claims. So sexual harassment, I'm not going to go into great detail here. I think probably most of us in the room understand what it is, but it's generally an unwanted communication, touching, something that is found offensive both from a subjective standpoint and an objective standpoint, meaning that the person who is being victimized subjectively feels like it's offensive, but then also from a reasonable standpoint, impartially, was that contact also offensive? That's sort of the legal standard, but most employers have a stricter, almost a zero tolerance standard. And so when we're looking at a complaint internally, we always have to be mindful of, is our policy and practice internally, is that more stringent than perhaps the legal standard? So in the medical industry, where do you see trends going in that direction? Are more employers adopting a zero tolerance type of policy, or are you taking an approach that favors more of the traditional legal standard?
Well, so I think that certainly we've recognized for a long time, I think in the medical industry, how important a healthy workplace culture is for everyone, not just the employees, but as well as the patients. So we really feel pretty strongly about bullying conduct and hostile work environment, even when it's not based on a protected characteristic. So our policies tend to be a lot broader to really get at sort of this problematic conduct in the workplace. And in fact, we have an agreement on professional conduct that all employees sign on their first day of work, just to make clear this is the kind of conduct that we expect, and this is the kind of conduct that won't be tolerated. So I think it's important to get that message out and to get it out regularly, but it's also important to model it in the everyday. It's not enough to have a policy or to have a training. You have to really be living those principles, and that's one of the things that we try to do. We've done a lot of training in the last few years, and this may be a sort of a buzzword that you've heard about around bystander training and sort of empowering individuals who are witnessing conduct that's not appropriate in the workplace to speak up, because sometimes those individuals might have a little bit more power in those situations, and it can sort of just help create more of, again, a culture that this sort of inappropriate conduct isn't going to be tolerated, and it doesn't have to rise to the level of actionable conduct for it to be wrongful in our workplace.
And that sort of concept of observing in a bystander role, perhaps harassment of another, discrimination of another, that's called associational discrimination, and that can lead to liability in and of itself. And I think that's also a concern here. I had a case last year where somebody who was a white male during the Trump election cycle was observing harassment of other coworkers and other third parties by his coworkers about racial issues, about gender issues, sort of centering around the Trump election. And this gentleman admitted that he was not the subject or the target of this type of discrimination, but he had enough to present an MCAD claim and get past a prima facie case for associational discrimination. And so that's also a liability concern that I think employers need to be cognizant of. It's also important to note, the Me Too movement focuses mostly on gender and harassment, sexual harassment. It can apply both ways. It can apply male to female traditionally, also female to male, like with the Hill situation. But I think it also can impact religious discrimination, race discrimination. And so when we're talking about the Me Too movement, I think it's not only just a protected class of gender, but it's also impacting these other areas. So an employer could be liable for other types of harassment that's not strictly based upon sexual issues. Have you seen an uptake, Kara, in your industry of other types of complaints, disability, race, religion, sexual orientation?
I find that, yeah, I mean, I think that for me, what I see the most challenging to deal with on a day-to-day basis is our disability issues. Because I think that a lot of the workforce is pretty educated. They know what, sexual harassment looks like. They know what racial harassment looks like. Disability can be a lot harder because, especially when you have an employee who is disabled and maybe their disability is not visible, and maybe they have different accommodations in the workplace that are putting pressure on managers. So when I'm thinking about sort of what sort of hostile work environments are out there, I'm really thinking holistically about really every protected characteristic. And, the Mass Commission Against Discrimination, obviously they have regulations and guidance on what their policies should look like and how often you should issue them. But I try to, every time we see that sort of guidance, stretch that to all of the other protected characteristics, because it's just as easy for any of those to become sort of a focus of wrongful conduct in the workplace.
You touched on training a few minutes ago, and I want to just go back to that issue. In your view, coming from an outside counsel role into an in-house counsel role, how often are you seeing employers in your industry conduct discrimination and harassment training?
I think it's something that everyone is struggling with right now, because I think people sort of had understandings about, like, we'll do an annual training or we'll do training during orientation. But then after Me Too, everyone got really nervous about, are we doing enough training? And I don't remember exactly the study, but there's been a number of statistics out there that have shown that poor training or training that isn't effective in some cases can make things worse. So you don't want to just take up people's time with a training that isn't going to be effective. So what I really have been trying to focus on, and I think other organizations are too, is to keep these trainings in person if we can, or interactive, or in some way sort of meaningful in a different way. Simply sort of parroting back the policy to employees. It's boring to them. It's not effective. They feel like, I know this stuff already. The really effective trainings are the ones that get into the gray areas and really ask employees to make tough calls. And again, I've been finding what I'm referring to as these sort of more indirect workplace culture trainings in some ways are more effective than just a standard, employment discrimination training, to really think about how do we be respectful to one another in the workplace? What are the power dynamics that are causing employees to act one way or another? So a lot of our diversity and inclusion training actually has been helpful to me in my world in providing the sort of baseline about what's okay in the workplace.
Can I mention one thing on that topic, just because it's very timely? Did anyone see the Ernst & Young, the story in the Huffington Post? And if you haven't, you might want to look at it, just to your point, because it's gotten a lot of press this week. It started on the Huffington Post. Ernst & Young did some sensitivity and cultural training. It was sort of women's leadership training, and it turned into a pretty large crisis for them because some of the ideas were antiquated and actually were pretty offensive to women. So I just want to mention that, is if you're doing trainings, make sure that you're thinking about, are they still applicable in today's environment? Are there things that need to be changed? This is something they've been doing for many years, and it's like very apparent now that it was pretty tone deaf in today's society.
Well, and some of it, I think of it almost as like do gooder error. So somebody who thinks that they really know the issues and they're on the right side of the issues. And I'm sure the person who gave that poor advice it was about how women should dress, right?
Yes. And more than that.
Right,
Yeah.
and I'm sure it was somebody who maybe had been in that person's shoes, had been sort of a young woman sort of coming up in an organization, was trying to share their knowledge and their experience, and coming from this really well-intentioned place that was just hitting a real false note with people and offensive to some people. So it sort of goes back to, and this is something that, I try to do, is make sure that when there's training happening in the organization, when people are speaking in a mentoring kind of way, that they've cleared some of these ideas, with legal or with leadership and HR, because that's where a lot of these sort of, slips happen.
So the next slide just demonstrates how complaints might come into an organization. On the left, we have the MCAD EEOC complaint. Sometimes we get, without warning, you get an MCAD complaint. In other words, the employee has not reported the harassment or discrimination. They've simply just, and many policies, I think most policies, reference that an employee can proceed right to the MCAD. And that's almost an invitation for them to do so instead of taking the first step and going to their supervisor or HR and reporting harassment. But you can get one of these complaints out of the blue, of course, and then on the right side, you have an internal complaint that's probably a lot more manageable in the short term. From a crisis standpoint, looking at it in the context of a high-profile individual, does that change the way you're going to address one of these complaints? Say, for instance, Kara, you get an MCAD complaint out of the blue for a low-profile employee versus a high-profile employee. How are you going to address those two situations differently, if at all?
I think probably not too differently. And I will just say, in regards to when they come out of the blue, I've yet to see a correlation between the matters that we know about before an employee is terminated and the ones that I advise on and we spend time on, and then what turns into an MCAD or EEOC complaint. So they are almost always out of the blue.
Right.
So, in terms of whether it's high profile or low profile, I think maybe the only difference might be in the communication strategy. So if it is a high-profile employee who's been named, we want to make sure that, again, our SVP of communications is alerted to this, and then anybody in senior leadership that we think might need to know about it. But then in terms of how we respond to it, it's pretty much the same. We want to understand, is this a current employee or former employee? We want to look at who's the employee's manager and make sure the manager is aware of it. We want to make sure the manager and anybody who might be named by that complaint is aware of our no retaliation policy. And we really make sure that that reach out is coming from somebody, either myself or somebody at a relatively high level in human resources, to really convey the seriousness of how to act. Depending on how closely the complainant and a manager might work, or the complainant might work with the person that's being named, we're also going to want to take a look at what is the complainant's, if they're a current employee, what's their working situation like right now? Are they coming into contact with the person they've brought the complaint against? And what's the right resolution? What would the complainant like to do? Particularly when you have the disparity in power, if your complainant is somebody who is really junior and there's a lot of positions throughout the organization that are very similar, we might want to see, is this something that would be appealing to you, or would you like to stay where you are? We don't ever want somebody who's brought a complaint forward to feel that they're being pushed into another position if that's not what they want. We're really focused on what would make you feel comfortable in the workplace. And then we have to think about what kind of measures do we put in place on a temporary basis while we're doing the investigation. So depending on the seriousness of the conduct, we may require the person who's been named as the bad actor to be out of work during this time. And they're put on an administrative leave. They're paid during this time, but they can't be here because we don't want them to disrupt the investigation. We don't want them to make the complainant feel any more comfortable. If there's not concern about any sort of disruption of the investigation or any sort of danger to or sort of threat to the complainant, sometimes they may stay in. Again, it's really going to depend on the seriousness of the complaint. We're also going to look at what their position is. Who are they interacting with? Are they interacting with the public or patients? And in that case, again, that's going to lean more in favor of the administrative leave. We tend to usually utilize that, but again, we have to be really mindful of how quickly the investigation can happen, because if the complaint is not a truthful one, or if there's no real merit to it, you've now damaged that person's reputation.
And we talked about getting a fresh MCAD complaint. The other alternative is you get a complaint, you have notice of it, it's handled internally. Have you seen circumstances where it's a legitimate harassment or discrimination claim, you do all the right things, you perform a quick and reasonable investigation, you take some remedial measures, and you're able to thwart that employee from filing an MCAD complaint?
Yes, yes, certainly. I mean, I think it's all about the employee being heard. I mean, I think the majority of employees don't want to resort to the MCAD if they're currently employed. They want to stay in their jobs and they want their jobs to work for them. And so they want to understand that their complaint is taken seriously, that they will be given some sort of a response when the investigation is concluded, and that there's some sort of result after they came forward. The other thing I just want to mention is regarding internal complaints. I try to make sure that my client is really well schooled on the concept that a complaint can come from anywhere. I think there tends to be a little bit of rigidity around what a complaint looks like and where it comes from. They think it's going to come directly to human resources, and they think it might come, we have an anonymous hotline where employees can also call. And so people expect the complaints to come there. They come from so many other different places. It can be a conversation between an employee and a manager. We've had them come in through workers' comp paperwork, where all of a sudden, embedded in there, we're seeing complaints of, a hostile work environment. So it's helpful to make sure that your human resources group and your managers, when they're training them, really understand complaints can come from anywhere. And you want employees to feel that they have a number of different avenues. We like to think of sort of 3 different avenues for the employee: our hotline, our human resources, and then the manager. Because you don't ever want to be in a situation where the employee said, well, I didn't know where to bring my complaint, so I went to the MCAD.
And I think from a timing standpoint, it's important to note that there's a pretty short statute of limitations for these types of claims. It's 300 days, so it's less than a year. And there can be continuing violations types of claims that are an exception to that, but in general, the employee, once the conduct occurs, has only 300 days to go file at the MCAD and at the EEOC. And so that's something that I think employers need to, recognize. The other thing is that once somebody cannot simply just resort to federal or state court and file their lawsuit. They have to first file at the MCAD, and those are confidential investigations that occur. And those investigations can last. I just had a probable cause ruling. In other words, an initial investigation come in yesterday. The complaint had been filed 2 years ago. And so that's a confidential investigation that really hasn't become public because it hasn't entered the federal court or the state court where the filings are public. So it kind of gives you a little leeway. Unless somebody has a very aggressive lawyer and they petition the MCAD to very quickly remove it from the MCAD and file it in state court. And then you're off and running because all of the public filings in federal court are public. So Sandy, when you're handling an MCAD complaint that maybe isn't public yet versus a lawsuit where you have very public allegations, how are you going to handle those two situations differently? I know that's a broad question.
Yeah, well, if it's already very public and the person's name is out there, you have to make decisions around whether you confirm or comment on that allegation around the person. And this goes back to how high profile the person is, what the allegation is, where your company is, geographically, if there's, context for this. If it's just the filing and it's still confidential, you can't, in most of these cases, you're not going to comment on any ongoing investigation. You can't. But you just don't want to say no comment. You have to, and there's not a lot of ways to say this, trust me. We keep trying to come up with fresh language, and the other crisis person in the room can probably say the same thing. There's only so many ways to say, as a practice, we cannot comment on ongoing personnel matters. But that is it at the end of the day. You can't risk, from a communication standpoint, wanting to be authentic and transparent and everything else, and then risk the legal cost, the litigation, losing the claim because you wanted to be authentic. It's always a balance. So you have to find the right words, and this goes also back to conveying sensitivity around the issue itself and people's privacy and people's rights and due process.
Right, and I think we're looking at this in the context of a current employee who has privacy rights. And like I said, the MCAD proceeding is confidential. And so I've had clients where the complainant goes out and makes very public allegations. Perhaps they've leaked through a third party to a media source, and suddenly you have this very damaging set of allegations that come out. In the meantime, you filed your position statement at the MCAD, which you think you have very strong defenses, and the accused sees this newspaper article and wants to very aggressively come out and deny the allegations and set forth all of our factual arguments. Essentially, here, reporter, here's our position statement. Why don't you give our side of the story? But I don't think that's really a prudent thing to do. And the advice that I've given is, we can certainly comment that there's an ongoing investigation, but what other types of things besides there's an ongoing investigation, Sandy, in a circumstance like that, can you counsel a client on?
Yeah, well, also, the more you put out there, the more that can come back and bite you, right? So the more you say, the more stories you're going to generate, the more that can be taken out, extracted, and used in other contexts. So you have to be very, very, very thoughtful about all the words you're putting out there, whether they're verbally, in writing, on social media. We have a client who has now former board member who was accused of something quite recently and went on social media and did his own video really, really aggressively refuting the allegation, and it was not, in my opinion, well thought out. It wasn't professionally done, and it just created more stories and more coverage, and it created more tension for our client about whether or not this person should be on their board or should be asked to step off because it was creating a lot of concern and drama. So the more you say, the more that's out there to use. One of the things that you said earlier, Kara, which I think is really important to note, is that you talked about when everybody comes on board, they sign something. It speaks to what the processes are, the culture, what people are expected to adhere to. When you have written processes and documents like that, those are things that you can go back to and use in your statements and what you're putting out there that speak to what you stand for as an organization. So you're talking about your culture, your values, your ethics, and how you do things as an organization and what you stand for versus the specific incident or the person. And those things are well documented, they pre-existed, and it's nice to be able to go back and reference those things.
I know we're gonna, do you have a question?
Yeah, so the globe went like industry to industry, and they said, oh, now we're gonna look at the restaurant industry, and now we're gonna look, and a lot of those things that were written, I don't know that they've been brought through the chain, if you will, the internal processes. So what do you do when people are out talking to the media, and there's not even anything on record in the normal course of things?
So what do you do when someone's...
In other words, if you're at Dana-Farber and someone's complaining to the press, but they've never come to any of the internal processes, and you go try to get them to go through the processes, or are you then inviting them to,
Well, I mean, my position is if they're a current employee, regardless of what sort of external processes they might be utilizing, we have an obligation as the employer to understand if they're experiencing wrongful conduct in the workplace. So I haven't run into that particular situation, but what I would advise in that instance is we need to sit down and talk to this person and understand, have you been experiencing this in the workplace? And if so, to me, that's a complaint. So, I mean, again, it's sort of getting my client to understand complaint is very broad. If an employee brings forth a concern about being poorly treated in the workplace, let's consider it a complaint and let's make sure we chase it down. Let's understand, what are you saying? Is there any truth to it? Let's sit down and talk to the person. Are there any people that can corroborate it and sort of begin an investigation? So I don't like to let sort of those external processes hold up us doing what we need to do as the employer.
And if I can just touch on it from a communication standpoint, I think that what I've seen with my clients is that most legitimate claims come through some sort of legitimate channel. It doesn't start with the media. The people that sort of threaten to go off the reservation, I'm going to call the media and everything else if I don't get my due process, tend to maybe not be the most credible claims because they're leapfrogging to that resort to get attention before they're really going through the process. And we have a client right now where the person is highly uncredible, non-credible. And he's in another country, and he's making these claims, and he's naming people, and he's doing all these things, and he's reached out to media, and the media are getting in touch with the in-house communications person going, here's the email I just got, what the heck? And the media people are saying, well, what did you interpret from that? And they're saying, this seems crazy, and they're like, And that's it. They're not covering it because it doesn't come across as credible. So I think most legitimate claims that I've seen have come through the proper channel.
And I think Kara touched on this a little bit, but the standard for initiating an investigation and whether an employer has reacted properly to a complaint is not whether they knew about it. It's whether they knew or should have known about it. And so that complaint that you referenced, a media complaint, that puts the employer on notice. So I think Kara's response was totally accurate and appropriate. You're now on notice, although it's not a formal complaint directly from the employee or filed at the MCAD. The first course of action would be to go and confront that employee, ask for a private meeting, and get some very basic facts about what their allegations are to show that you responded, you performed a reasonable investigation, and then see where it goes. I had a claim last year where a third party reported a touching of a coworker by another coworker to management. Management grappled with what to do here because the individual who was the victim did not complain directly. So they called their counsel, and their counsel said, well, why don't you discreetly approach the employee and just ask them if something inappropriate happened and see what their response is. So that's exactly what they did. The person who was victimized responded that, well, this was an innocent touching. I really didn't take offense to it. It was innocuous. They documented it. They moved along, and sure enough, 6 months later, they got a MCAD complaint, but they had that to go back on. Had they just ignored the situation and it came out that, well, it was reported to you, but you didn't even initiate an investigation, that would have been highly problematic from a liability standpoint. So I think regardless of how you get on notice of a complaint, internally, MCAD, third party, you got to respond in some form or fashion to it.
And that's one of the things I've tried to work with my internal clients to understand is that people sort of have these preconceived notions about what an investigation is and what an investigation means in an organization. And what I try to help them understand is it is just a response, and it can have varying levels of formalities, but it's a response. It's understanding what the person is complaining about and then looking into any supporting facts, trying to understand the entire picture, and then sort of coming up with a response based on that. So anytime we get a complaint, there's always going to be a response. And that response is essentially an investigation if we're doing it in the right way, whether or not you have a 20-page report or you just have pages of notes saying, here's what I did.
I have a question. If the employee has opted to start the process at MCAT and you now have this obligation, do you run the risk of potentially at least being perceived as interfering in the MCAT investigation by virtue of, making a somewhat public, have the employee come in, sit them down, whatever the power dynamic is there? I mean, when you're advising clients about, go drag them in, take them off the work floor or whatever, and sit them down and say, what the heck is going on here? Do you run that risk that you're potentially trying to impact that MCAT complaint?
I think we always have to be really mindful over who is sitting down with the employee. And so most of the time that's not me, because people have ideas about who an attorney is and what an attorney is. So, I'm very lucky to have incredibly experienced and empathetic colleagues in human resources who have had some of these conversations and have been able to diffuse, really big lawsuits because they've been able to sit down and understand what it is the person is really concerned about. But going back to your original question, one of the tools that the MCAD has is an early mediation program. And so I do try to take advantage of any opportunity to sit down with the employee in that setting as soon as possible. And that way you have at least the structure and the protection of that mediation process so that the employee is not maybe feeling as pressured as they might be as if they were sitting in your office. And that's actually been an effective opportunity to speak with an employee. I mean, I've had employees who felt very heard out of that process. And in one instance, we had an employee just drop the claim altogether after really understanding, because they were for whatever reason, they weren't utilizing the right processes to bring forth their complaint. And so to sit in a room with them and say, okay, I hear your complaint and I've done all this research and I want to explain to you what I've learned, that can be really powerful and can go a long way.
I think in crisis communications generally, sometimes people need to feel heard and feel that something is being done about what they're concerned about in this type of matter or something else. And that can often diffuse a situation before it gets really out of control.
I think that's an interesting question from a legal standpoint. You know, you've got a pending MCAD complaint. That person might be represented or they might not be represented by an attorney. I'd say 90% of the complaints I see come in from the MCAD, there's not an attorney involved yet. Or maybe there is, but they're behind the scenes. But you've got a current employee. You don't want to interfere with the MCAD's investigation, but the employer still has an obligation to take remedial measures and perform an investigation. And so you can't just simply because the MCAD complaint has been filed, go into defense mode, send your position statement into the MCAD, and start shutting down channels. I think you need to be proactive, and I think you need to make sure, in conjunction with your counsel, many times outside counsel, that you're taking steps to address it. If they are represented, perhaps you're doing that directly through the attorney, separating perhaps that employee from the situation if they're perceived to be being harassed by a supervisor. Merely because there's an MCAD complaint does not take away the employer's responsibility to take those measures. So I would encourage very proactive steps. Kara, do you agree with that?
Yeah, absolutely. It's funny, when I was thinking about that question, I initially went to the pro se plaintiff, because it is rare to see attorneys involved with a complaint that we knew nothing about go straight to the MCAD. We usually will get a call from the attorney first that the employee's consulted. And there's a lot of negotiation or understandings that happen prior to the complaint being filed, so that we do have an opportunity to address the employee's concerns through their counsel. So a lot of times it's easier when there's counsel involved, because at least we're speaking the same language.
Right, and this kind of leads into our next slide, measures that we're going to take upon receiving a complaint. And there's a couple bullet points here, but I think one of the key ones is preservation of evidence. I mean, that's something that oftentimes, you have the 300 days to file a complaint. It might sit at the MCAD for a while, and as an employer, as soon as you get notice of that complaint, you need to take measures to preserve evidence, because lock down witnesses with statements, because the lawsuit might not be resolved for another 2 or 3 years, sometimes 4 years after that initial complaint. So what initial steps, immediate steps, are you going to take as an employer when you get maybe a high-profile complaint in about an executive that is going to have some media attention?
Sure. Well, again, I think it's going to depend on what sort of, what the substance of the complaint is. So we have to, first of all, determine if anybody is at risk because of the complaint, whether it is the alleged perpetrator or the alleged victim. We want to make sure that nobody is in a place where they're still feeling uncomfortable in the workplace. So we take a look at the workplace to kind of understand what's happening. That's sort of the initial step. But then, of course, we want to make sure that communications is involved. We obviously will be working, if it's been filed, if it's turned into some sort of legal process, then we're usually going to have outside counsel involved, and they'll conduct the investigation. If it hasn't turned into process yet, if it hasn't gone to the MCAD, or if it's not in court, we will usually hire an external investigator, depending on, the seriousness of the complaint and the parties that are involved. So we have sort of this objective, sort of separate process, and also from sort of a speediness perspective too, because our human resources department is really overloaded. So if they have something that is really crucial that they act on pretty quickly, it's pretty hard for them to turn around an investigation in short order. So if there's been a complaint filed, then we know that the investigation is covered by attorney-client privilege, and it's going to be part of the defense. If that hasn't happened, then we want to be mindful that this investigation might be a tool we want to use later. We may not want privilege to apply to it. So we try to make sure that we've sort of segregated what the legal defense of the Institute is and what those conversations look like, and then what is part of just the normal doings of the investigator, sort of communicating with human resources to get the information they need and set up the interviews. So we try to be mindful of what my role is at that point.
Can I touch on one
Yeah,
thing?
sure.
So I just want to mention the reason that you want to get communications involved, or at least tell them in this early stage, particularly if, as you said, it's somebody high profile, is that something could be bubbling up on social media, and if the team that's monitoring your social media doesn't know what to look for, they don't know what's bubbling up. They could get a call from somebody from a media outlet and have absolutely no idea what's going on. And also, they're not prepared for what might be coming. So they can't just get a holding statement together, which is, a statement to be able to use in response if they need it quickly so that you don't get the no comment or could not be reached for comment. So there's reasons to pull them in, and it doesn't mean that they have to do anything right at that moment, but their radar has to be up, and they have to be prepared for what could come next.
You also have to think about the politics. So if it is a very high-profile person that has been accused, you have to think about, before you start that investigation, who are they going to complain to about the investigation, and make sure that that person knows about it, knows it's happening, and is comfortable with the process, because that will likely happen.
And think about also if there's something, if it's right before your gala, or, where somebody was expected to be a presenter, or right before a trustee meeting, or there's a big donor that's about to come in. There are episodic, specific instances where somebody might have a question or need to be informed that you have to really think about the big picture. And communications might be more aware of those things than somebody in HR.
So the next area is the investigation itself, and what sort of factors go into the investigation. I think it's important that, and Kara touched on this, that there's not one size that fits all. I mean, sometimes you might have an HR level person conduct the investigation. They might interview one or two witnesses, document it, recommend some sort of conclusion, remedial measures, maybe not. And then that's the end of it. Other occasions, you might take it to the level of an in-house investigation. Sometimes you might have an external privileged investigation, and sometimes you might have an external non-privileged investigation. And I know this probably, I can sort of predict what the answer might be. It depends on the situation. But how do you make a decision, Kara, whether you're going to send an investigation externally versus keeping it in-house?
So again, it'll depend on what sort of complaint it is. How serious is the conduct? If the conduct is very serious, then it'll probably need to be a lawyer who does the investigation. And then we're going to look at who are the parties involved. If the parties are at a certain level within the organization, usually we're going to send it outside. Again, it tends to carry more weight sometimes to have this external investigator come in and do it. And even though that external investigator may be a lawyer, they're not acting as a lawyer when they're there. They're there to do the investigation. But again, when we do get these more informal kinds of complaints, or complaints that don't really involve serious conduct or sort of big players, HR usually will do those investigations. It's important for your human resources team to have some sort of consistency in how they're doing their investigations, and so you can spend time sort of training them on those issues. You also want to make sure that there's, again, appropriate speed and appropriate follow-up when they're doing their investigations as well. So yeah, I think those are sort of the bigger things we consider.
When would you consider getting somebody like Sandy involved to coordinate with your outside counsel, or even keeping that person abreast of what's going on with your investigation, and sort of in the context of a high-profile executive?
I think it depends what your in-house capabilities are. I mean, we're very fortunate to have a pretty built-up communications team. So I do certainly start with them. Anytime it's really serious conduct, again, or more high-profile people, we're going to work with communications. And then they will make decisions if something is at a certain size. They may also want to work with an external communications team.
how do you decide if it's going to be a privileged investigation versus a non-privileged? I think you mentioned that this report, sometimes it can be relatively brief, 5 to 10 pages. Other times, depending upon the number of witnesses, it can be 50 pages long. And so how do you decide whether it's going to be a privileged investigation, in other words, conducted by an attorney and communicated directly to you versus a non-privileged investigation?
So we start from the point that I think I put privilege on the investigation from the beginning, but with the understanding that I may want to waive that privilege at some point, or we may want to create sort of another type of document that is a non-privileged document. But in any investigation, I find that the reports tend to be very voluminous, and people just don't have time to read them, and there's sensitive information in them. So I usually will request sort of a shorter summary report from the investigator that can more easily be shared with sort of an executive team, or that if it were, if we decided that it was non-privileged, this would be a document that we might want to share with the employee if it was necessary.
And go ahead.
Can I just mention privilege from our standpoint too, is that almost every single time when we're brought into a matter, we ask to be engaged by the law firm that's representing the client, not directly by the client. Although, I mean, you can speak better to this, it's not perfect in terms of protecting privilege. We're brought on board as media counsel to the legal counsel. And so we make sure that everything that we're doing in communication with our client, legal counsel is copied. We are very careful about what we put in writing. We're very careful to make sure legal counsel are involved in important phone calls, because anything that we're doing could ultimately be part of the discoverable work.
If it's that sensitive, generally, the attorney should be the only person communicating with Sandy, and the written communications ought to be limited as much as possible. There are decisions out there that if you're simply copying your counsel on it, doesn't necessarily make it attorney-client protected. So I think from the lawyer's perspective, the less writing, the better in those types of situations. And I think that the public relations person ought to be retained by the attorney, and those communications can be funneled through the attorney and then on to management. I think that's the easiest way to deal with it. We've only got a few minutes left, so I wanted to move ahead to PR strategy and why it's important in this sort of age of Me Too.
So I'll go, how many minutes do we have? Okay, I'll go pretty quickly through mine. Yeah, I'll go pretty quickly. So first of all, one of the reasons it's important to have a strategy is a lot of what you heard earlier today. You saw the PR blunders. When you're not prepared, you make mistakes. So having a PR strategy that is strategic and not reactive, is strategic and not tactical, but considers the tactics, is really important. Just like with anything, preparation prevents, you know that adage, right? Whatever performance. So, and it's important for communications and legal to be aligned. And there used to be this sense that, communications teams want you to say everything and the legal teams want you to say nothing, and they're just like this. And I really don't find that to be the case. If your communications, whether they're internal or external or a combination of both, are truly thinking about your risk, that's not the case that they're trying to get you to put a lot out there. They're thinking about risk and then backing into how does communications help protect you from that risk. And your legal team, same thing. They're not just trying to shut everything down, because they understand now, I think, and particularly because of the advent of social media changing this, they understand brand reputation is also a risk. It's not just a lawsuit that they have to worry about. So having those two teams in place, knowing how to work together, knowing who the people are, how to engage quickly is really important, because there is no time to sit around and think about what you're going to say. This goes back to the communications plans, having a crisis plan. If you thought through the things that keep you awake at night. We have a client right now who is a very large organization that we've been working with on proactive, positive PR for a number of years. And until very recently, they didn't have a crisis plan. One of our internal clients said, well, it's all up here. It's like, oh my God, what if you are out of the country? What if you're hit by a bus? Like, what if? And he said, oh my God, I know, we have to do it. And it can't just be up here, because there's so many people involved. There are the people that have access to your social media channels, who could be on vacation or could be out, and then you need to know who's your next line to get in to monitor or post or take down or put something on your website. There are people that you might need for translation purposes. I mean, there's so many nuances to what you could have to face in the heat of the moment that if you've not thought ahead about how you're going to handle those things, you will be caught off guard and you will not have the optimal response. You also have to think about who all your stakeholders are. It's not just the communications people are thinking about, what do we say to the media? What about your trustees, your employees, your patients, your elected officials that are important, your referral sources, your vendors, you know, and on and on and on. Investors, depending upon your organization, you have legion of stakeholders that could be affected or notified or need to be communicated with in a number of ways, and not all the same way. And there may be very specific people that need phone calls and VIPs that need to be highlighted. And do you know how to reach them? And who is the right person for reaching them? So, you know, and that's the tip of the iceberg. And I just use those points to illustrate the fact that there's a lot to think about. And when you have something breathing down your neck or calls coming in from the media, you can't possibly remember all those things because you're moving very quickly. And so getting it all ahead of time prepares you for making a mistake, and you've made decisions already when things were calm. One of the biggest mistakes that I see happening with clients is when they have all agreed to operate in a certain way, and there's sound reasons for operating that way, and those decisions were made when cooler heads prevailed, and then the you-know-what is hitting the fan, and then there's like a chink in the armor, right? There's somebody's going, maybe we shouldn't, maybe we shouldn't. I'm seeing a lot on social media, we should go the other way. And then people start to get anxious and worried, and they start to want to go in another direction. It's natural that when you feel under pressure, it's very hard to sometimes stick to a plan or say nothing or let things play out when you know, information could be put out there that is contrary to what you're seeing. But there's sound reasoning for that plan, and when you start to divert, is also when we see, and I know that you both have participated in things like this too, I'm sure, 3-hour conference calls where everybody's editing a statement as a group. I mean, and then guess what? The statement didn't go out for 3 hours and the story ran without us. So it's really important to think about how you're going to handle things, because all of those little slip-ups add to real communications misfires that hurt your brand, hurt your message, and can hurt a legal case.
Well, a perfect example of that was I keep coming back to it, but the Matt Lauer situation where Andy Lack, who was his supervisor, came out very quickly within days of the allegations and denied all of them very, very strongly. And it came out later that he had knowledge of many of these allegations and many of the complaints, and clearly there was a miscommunication there between the communications team, legal counsel, and you're grappling with probably a very aggressive type A personality who wants to get out ahead of the story. What elements, just from a bird's eye view, Sandy, do you encourage your clients to have in their crisis management plan, just from a bird's eye view without delving into the weeds?
Yeah, so first of all, you have to trust your communications team to be acting in your best interest and to do their job, and you have to tell them what's going on. And 9 times out of 10, when I get a call, an inbound call from a crisis client, whether they're new to us or not new to us, they tell us everything that's going on. They tell us what they're worried about, why this could be a problem. We ask all the right questions. And I always ask the question at the end, what else is going on that you're worried about? What else is happening? Has anything like this happened before? Is there something else? Almost every single time there's like, oh, well, yes, there is this one other thing. And they haven't said it out loud. It's sort of like if you don't say it out loud, maybe it won't be real. It's real. It's still real. So you have to tell your team and trust them to know what you're worried about or what other things could be percolating so that you don't compound a situation by not having a full picture. So in the planning, you need to have, in a good communications plan, you need to have, who is the communications team, the crisis team. A crisis plan for communications is not the same thing as having an emergency response plan. A lot of organizations like higher education institutions, hospitals, large corporations have their emergency response plan. It says where to shelter in place and how to notify people, by phone, but that's not the same thing. And so the communications plan talks about who gets involved in what situations, who is the right spokesperson in what situations. I firmly believe that it's not good to have the external PR firm be your spokesperson because it doesn't convey authenticity and sincerity and a grasp of control of your own internal situation. So who's the right spokesperson for every type of matter that is in your plan? And then where are all the passwords? Who are the people that handle certain things? How could things play out? We have communications trees, like a whole chart, flow chart for who communicates what to whom through what channel in different types of situations. And we have holding statements for every type of a situation. We have one client that is a very large faith-based organization with multiple, like almost like subsidiaries, if you will. And we have a crisis plan for them that has 23 possible scenarios. We've worked with them for about 7 years. And in those 7 years, 17 of the possible scenarios have happened. And they have not all blown up into horrible episodes of crises. And I'm not going to say that every single roadmap we had for all of those 17 things was exactly what we ended up doing, but it's pretty close. And so when you have something in place, you can react so quickly, and we can tweak that holding statement or figure out somebody actually would be better for this reason right now to be the spokesperson, but you're so much more prepared to go. So it's a roadmap and it's a strategy.
And from a legal standpoint, I'm thinking about down the line when we're in litigation, and perhaps that document becomes discoverable. And so from the lawyer's perspective, I think it's important to have consistency with the way you're enacting that policy and follow through. So you could find yourself tripped up, not only with not following through with an investigation, but you have these policies in place and suddenly you're not following them. So I think consistency and commitment to it are two important elements of it as well.
And you want to think about everything that could happen too. So in the previous presentation, there was the video with the guy drinking the water being asked about people who don't have water. Like the good communications person should not give the guy water. Like not even just should they not reach in and take it, they should be thinking like, don't have a water in this picture. That would be, that would be horrible. Or the example where the person couldn't answer the question about the bonus and the PR person, and I could feel for that PR person was trying to step in and say like, cut, we don't want to talk about this. But the CEO, whatever that issue was something they should have known somebody was going to ask. They should have been prepared with an answer. So it just goes to your plan can be a really good roadmap, but you have to take into account what is happening today, what is happening this week, what's in our organization, in our industry, in our region that could play into how this plays out.
What are can you give us some anecdotes and maybe some stories about clients who didn't have a plan in place, a crisis management plan, and then suddenly, what hits the fan? What are some of the pitfalls if you don't have a plan in place?
Well, one of them I mentioned, it's sort of trying to make decisions by gigantic committee that really slows things down. It's one of the most frustrating things that we deal with, and everybody on that committee is well-intentioned, and I'm sure there are political reasons for including all those people in that committee. Far be it from me to say in somebody's organization that their 17 trustees shouldn't be on the call. But that's a huge problem in slowing things down, and you're never gonna have everybody agree. And when you're parsing words, it's really to the detriment of the program.
Karen, your industry, do you see in-house counsel getting involved with that communications plan? Is that an element of perhaps in your industry what's included in a plan?
Yeah, and actually that's where I think that in-house counsel can be uniquely useful in these scenarios because we are embedded with our clients, and so we understand their mission and we understand their goals from a PR perspective, I think in a different way. I've certainly had situations where outside counsel, it's so much easier to say no comment, but of course, any sort of comment is going to, just create more headaches and complications and things you have to think about down the road. On the other hand, we have our, our communications team, and they never want to miss an opportunity to be able to speak about our organization and our mission. And so a lot of times I'm kind of this mediating voice in the middle to try to bring the parties together. And so I think that, we try to sort of apply sort of our legal, training to the statement that communications wants so that we're able to sort of accommodate kind of both parties at the same time.
I wanted to touch on this last slide because I think it's really one of the most important slides that we have. What you can really say in an investigation. Sandy, when do you, and you touched on this a little bit already, but when do you have, how do you decide who's going to release a statement or give a press conference or come out as the public face of your organization? You said that you prefer not to have the Castle Group be the spokesperson, but how do you engage in that decision-making process?
Yeah, I mean, it's a collaborative process with our clients and with the legal counsel. So there's not a one-size-fits-all answer to that. You have to decide who is the best person. And with some higher education institutions, going back to, the Me Too topic, sometimes it's the Title IX person. That's the best person because they're closest to that issue. But if it's something very visible, it should be the president. But what if it's about the president? Then is it the board chair? I mean, there's not a one-size-fits-all. That's the other beauty of having a plan, is that you have kind of plan A's and plan B's for what to do. You can't talk about the person that's being alleged. We covered that already. And it's very difficult if it's already out there, if there's allegations on social media, people are piling on. We were talking earlier about social media, and it's not just the channels that you're using, that your organization is using, that you have to monitor, because there are a lot of closed Facebook groups or advocacy groups or other places where chatter could be happening that you need to be aware of and think about following to see, is this person being named? And we have a lot of conversations with clients about, all right, the guy's name, it's usually a guy, but the guy's name is out there. Do we include them in our statement? Do we include them in our Dear Community letter? When do we, when don't we? There is no one size fits all. It sort of depends on how much it's out there. Is it a current allegation? Is it a recent allegation? Is the person alive? Are there lots of other people piling on? So there's not a one size fits all, and that's why it's very important to have your in-house team and sometimes an outside team also who can be objective and who has seen it play out in different ways with different types of organizations.
What are the core elements? Again, focusing on a discrimination and harassment claim, it's pending, it's at the MCAD. What are some of the core elements that you're recommending to clients to include in that public statement, knowing that you can't really address the actual incident itself?
Authenticity, sympathy, empathy, and understanding of the seriousness of the allegations. It's also an opportunity to put some positive messaging out there about what you stand for. I think I touched on that before, to reiterate what you might have a mission statement that speaks to this that you can quote, or something in your human resources handbook, something that you can go back to say, these are the words that we live by, this is what we stand for, and this is why this is very serious to us. You don't have to say that it's right or wrong, you believe him or her or whomever, but you're taking it seriously is really important. And then also, if you can, outline what is going to happen. There is a process, this is what it looks like. We will come back with findings, we will release them or we won't release them, but people want to know that something is happening, and in a lot of cases that I've seen, things become crisis when there's a void in information. People don't hear what's happening or know that the follow-up is being followed up. People start to get itchy and antsy and go to social media or to your point, call a reporter.
So we don't want to cut into everyone's lunchtime, so I think we'll conclude here, but does anyone have any questions before we formally conclude? All right, great.
Oh, sorry, I have one. One question. At the onset, you mentioned that there's an increase in claims right now in the current environment. Another thing I think we seem to be hearing a lot is that a lot of men are stepping back and say they're afraid to mentor and sponsor women in particular. What can employers do to make sure that people aren't being left behind, especially male-dominated industries and roles where that mentorship and sponsorship is important? As employers, what can we do to make sure that those underrepresented groups are getting the career opportunities and support that they need?
So I think it comes down to sort of what sort of diversity and inclusion policies and culture are you creating, and also educating your workforce that if there's a lot of different ways to mentor and to network and to sponsor. I've certainly heard that before, that concern. And so then the question is, well, what are the activities that you're doing for mentoring and sponsoring? And are there alternative ones that we can talk about? Or is it just come down to educating, like, this is not what you should be thinking about. You need to be thinking about people's careers, and you need to be thinking about them in a neutral way without considering this, and helping people to understand that this is about bad actors and this is about legitimate claims. This is not just the mere fact that you have a meeting with a person of, you know, the opposite sex in your office with the door closed. That doesn't mean there's a claim, as long as you're doing what you're supposed to be doing. So, I mean, we try to sort of, it hasn't come up on as sort of like a large-scale issue. It's more just been something that we kind of emphasize.